Good morning, everyone. I'd like to welcome you all to this Shepherd and Wedderburn seminar. I am Ian Drummond, a partner in our construction disputes practice, and we have four speakers for you today. The first speakers are Lauren Thompson and Alistair Kennedy, who will be discussing the topic of the current trends and challenges in the construction industry. And our third and fourth speakers are David Anderson and Chiara Pieri, who will be giving a case law update. Now, the plan for today's session is for the talk to last around 55 minutes. So we intend to bring the presentations to a close at around about 10:30 a.m. And the intention is for there then to be around 10 to 15 minutes for a Q&A session. And during the session, I would invite you all, please, to address any questions you have to the panel by way of typing these in to the Q&A box that you'll find on your screen that's on this IT platform. So please type them in at any time during the session, and we will pick those up at the end. If it happens that we run out of time to address them all, then what we'll do is we'll answer them by email after the session. And just as a reminder, the session is being recorded, and a link to the recording will be sent to you all in the days that follow this session. So just before I pass on to the first speaker, just a couple of admin items. Speakers, can I remind you all, please, when you're not talking, to keep yourselves on mute to avoid any feedback. And for the avoidance of doubt, all of you as the audience, you are currently on mute, and that's centrally controlled, just to avoid any noise interference. So thanks for you all attending today, and we hope you find this session interesting. Just one final point is that we have a couple of polls that we will be doing during the talks, and I expect to introduce the first of those polls at the end of the second talk, and I'll ask you to complete the polls, which will take just a minute or two, and hopefully that will give us some interesting feedback on the questions asked. The second poll will be taken at the end of the presentations, and again, I'd ask you all to answer the poll so we get a good cross-section of feedback on the points that are discussed in the poll. So thanks very much. That's the end of my introduction. I'll now pass over to the first speaker to begin the formal presentations, and that's Lauren Thompson. Thank you, Lauren.
Thank you and good morning. My colleague Alistair Kennedy and I are going to talk about some of the key issues that are regularly coming across our desks, and no doubt your own desks, and that are affecting live projects on site or giving rise to queries where projects are still in the procurement stage. Those involved in the construction sector are being bombarded with dire statistics at the moment, particularly around labour and material shortages. And whilst these topics will be the focus for my discussion today, I do want to suggest that it's not all bad news. According to data from the Construction Products Association, following total output falling by 44% between February and April last year, construction output in May of this year surpassed pre-pandemic levels, with activity forecast to rise 13.7% in 2021 and 6.3% in 2022. The HIS Market SIPS UK Construction Purchasing Managers Index reached a high of 66.3 points in June. Although this has decreased on a month-by-month basis since, perhaps largely to issues surrounding labour and materials, the September figure is still 52.6 points, and this does represent growth. A reading above 50 indicates activity is expanding. I think it's fair to say we're in the midst of what we've seen described in the construction press as a perfect storm, as we see demand for development increasing, but at the same time being accompanied with a significant number of supply risks, primarily labour and material shortages. One of our colleagues was on a call with the CBI this week, who cited that over 75% of businesses across the UK view access to labour as a threat for their business. And this is not just an issue affecting the construction sector. CBI advised that, say, the Gleneagles Hotel has 700 vacancies at the moment. An IT company in Inverness currently has 500 vacancies. The latest ONS data, as at late August, showed over 35,000 construction jobs on offer across the UK. This represents a 20-year high. Like the hospitality sector, labour shortages in construction have been particularly exacerbated by the fall in EU workers on site. The Financial Times reported that between the first quarter of 2017 and the first quarter of 2021, EU construction workers fell by 51% in the UK and by 63% in London, as workers returned to EU countries. Since the introduction of the points-based immigration system on the 1st of January, there have been fewer construction workers arriving from EU countries. The RICS Quarter 2 UK Construction and Infrastructure Monitor Survey noted 2/3 of respondents identified issues around labour, both for skilled trades as well as what we would traditionally be viewed as white-collar roles. So for quantity surveyors, 45% of contributors signalled a shortage of this profession. For bricklayers, the figure was 58%, carpenters 55%. Construction activity in the last couple of months, like other sectors, is also being affected by the pingdemic, as employees throughout the sector supply chain require to isolate after coming into contact with someone who's contracted COVID-19. In terms of availability of construction materials, 82% of respondents to the same RIS Quarter 2 survey said a shortage of materials hampered the market during the second quarter of this year, up from 57% in the previous quarter. The survey also estimated that the cost of materials is expected to increase by over 10% over the next 12 months. This follows the ONS reporting a 20% rise in the cost of materials between July 2020 and July 2021. The consequences of Brexit are still being felt. According to the Construction Law Council, roughly 60% of imported materials used in UK construction originate from the EU. A number of supply lines of key materials are being affected, particularly timber, of which the UK imports approximately 80% of its use. Delay in delivery of materials has also been affected by the shortage of haulage capacity due to a lack of delivery drivers. Construction businesses are one of the largest users of the road network, and the Road Haulage Association has advised that the UK has lost between 15,000 and 20,000 European drivers this year. However, there are some early signs that supplies for some materials are now improving. A joint statement from the co-chairs of the Construction Leadership Council's Product Availability Working Group suggested that while extended delivery times are likely to persist until the end of the year, we are now in a better position than 3 to 4 months ago. The shortage of cement, which is one of the hardest hit products, saw an improvement in August as additional supplies were sourced from abroad. It remains to be seen whether continued issues with transportation via haulage and ports and rising energy prices will halt this improvement. So how does this affect projects currently on site? Does a delay in availability of materials entitle contractors to an extension of time or additional monies? The JCT and SPCC contracts allow an ability to claim an extension of time on the occurrence of defined relevant events. These include strike, lockout, or combination of workmen which affect any trade employed upon the works, or engaged in the preparation, manufacture, or transportation of any of the goods or materials required for works. There's also the exercise after the base date by a UK government or any other local or public authority or any statutory power that directly affects the execution of the works. And while elements of the above have affected the supply chain, it's hard to neatly attribute the current circumstances into either of these relevant events. A party may try to argue that the current delays fall within the ambit of force majeure, another relevant event under JCT and SPCC contracts. This might be the case for, say, a contract entered into before the COVID-19 outbreak, if material shortages can be linked to the associated global fallout from the pandemic, although this is still a hard test to satisfy. Certainly for more recent contracts, it's highly unlikely that the JCT-SPCC force majeure threshold will be met, as the fact that it's simply more difficult or costly to perform the contract is not considered enough to meet this test. There does not therefore seem to be an obvious route for securing an extension of time pursuant to JCT or SPCC contracts. Where the cost of materials has been factored into the prices agreed at the time of contracting, there might be limited or no opportunity for the contractor to have these prices amended. So for longer term projects, the current circumstances may be very different from prevailing market conditions when the contract was concluded and the pricing agreed. JCT and SPCC contracts do not allow for loss and expense in respect of mutual events such as force majeure, changes in law, or strikes, etc., which affect trades. As such, a contractor is likely to have to demonstrate a change to the works or delay or impediment by the employer, and that's likely to be challenging in the context of materials. In terms of NEC contracts, it's worth highlighting the underlying ethos of the contract for the parties, the project manager and the supervisor to act in the spirit of mutual trust and cooperation. Parties may therefore cite this provision in terms of their discussion around material availability and cost. This NEC contracts do offer a more favourable risk profile from the contractor, and that compensation events will permit an application for both time and money, even where neutral. However, contractors still have to face the same hurdle of establishing the fact that a compensation event has been triggered. There are also the various pricing options under the NEC frameworks that include price contracts, target contracts, and a cost reimbursable contract. So the effective increased cost of materials will depend on the pricing option. So is it cost reimbursable? Is there a pay and gain share in relation to increased costs? In addition, any change depends upon the X option selected as part of the contract and any Z clauses which will amend the standard conditions. Clause 60 under the NEC contracts, the compensation provision, sets out the basis on which the contractor is entitled to additional time and money, and the following compensation events may be relevant. So under clause 60.1.1, a project manager may give an instruction changing the scope. A change in scope may be agreed by the parties as a result of unavailability of materials. Under clause 17.2, the project manager and the contractor must notify the other as soon as it becomes aware that the scope includes an illegal or impossible requirement. And if that's the case, the project manager must give an instruction to change the scope appropriately. Depending on the facts, this may cover the situation where plants and materials manufactured overseas cannot be delivered to site. Clause 60.1.19 covers acts of prevention. There's no reference to force majeure in NEC contracts, but clause 19 prevention and clause 61.19 deals with force majeure type events. So the event must stop the contractor completing the whole of the works, either completely or by the date for the planned completion on the accepted programme. It must be an event that neither party could prevent, and an experienced contractor would have judged to have had such a small chance of occurring, it would be unreasonable to have allowed for it. A similar analysis is likely to apply as in JCT SBCC contracts, in that market availability will have to result in delay to the works or preventing the works altogether, and not simply resulting in an increase in the cost of materials or the contract being harder to perform. It's also worth remembering that parties are required to comply with the processes regarding early warning and risk registers in NEC contracts. So clause 15.1 of the engineering contract requires the contractor and the project manager to give early warning to the other as soon as they become aware of a matter which could increase the total of the prices, delay completion, delay meeting a key date, or impair the performance of the works. And this risk should then be reflected in the risk register, with parties working collaboratively to manage any time or cost implications. It's also important to note that failure to issue an early warning notice can have a negative impact on the assessment of a compensation event, and that compensation event notices must be made within 8 weeks of becoming aware of the event, or the claim will be barred. Fluctuation, indexation, or escalation clauses may be proposed for contracts that are still being negotiated. These provisions are found in many standard form contracts, including JCT, SBCC, and NEC. An example of such provision is in the NEC 4 conditions secondary option X1, which provides for index-linked price adjustment. The obvious downside to an employer is the inherent lack of price certainty. However, this may be palatable where the alternative is to accept a tender price based on a worst-case scenario of materials costs. These are generally optional provisions, and for the last decade or so, our experience has been that these are often deleted or disapplied from contracts. Our experience of the current market remains that this is relatively unusual for the contracts to be concluded, including these price fluctuation options. Moving away from pricing mechanisms within contracts, are alternative materials an option? Whether or not a contractor is permitted to make a change to the materials that are specified in a contract will of course depend on the agreed specification and the full contractual terms. Often material change to the specification will only be permitted with the agreement of the employer. In this scenario, it's also important to consider any agreements with third-party stakeholders. So development finance agreements, purchase agreements, or agreements for lease may also have restrictions as to options for substituting materials. So in summary, for ongoing contracts, what should parties be looking at? Carefully check contract terms and see if they've been amended. What are the entitlements for time and money? Is there a pandemic or a Brexit clause, and what is its scope? Unless catered for in the contract, the risk of price fluctuations will remain with the contractor. Communication is key. So a pragmatic approach may be best with parties working together given the complexity of the issues. It may be possible to agree to vary or renegotiate contract terms to address specific issues, or to look to use alternative materials or resequence works. When looking for solutions, parties should be mindful of the contractual consequences and whether any instructions could lead to contractual claims for extensions of time or loss and expense. So if there's an agreed solution between the parties, consider whether it is more appropriate to vary the contract and prescribe the agreed consequences. Remember that a contractor is often subject to an obligation to use reasonable or best endeavours to mitigate delay or loss and expense. So consider what practical and commercial steps can be taken. So regular, early discussions with the supply chain, considering alternative suppliers, storing materials, and exploring alternative materials. For new contracts, if there's issues with material availability and costs that are anticipated, consider whether they should be expressly dealt with in the contract. So could specific extension of time or loss and expense grounds be limited to small numbers of clearly identified issues caused by delay at port, for example? Consider whether the drafting around substituting alternative materials should be altered to allow for greater flexibility with clear approval processes. Contractors should also consider the terms that they're able to obtain from their subcontractors. So many subcontractors may find themselves unwilling to accept the risk of material unavailability, price increases, and contractors will need to consider how to mitigate these risks. As well as discussions regarding risk allocation in terms of time and money. From a practical perspective, the shortage of materials is leading to an even earlier number of advance orders being placed. Developers and contractors are looking to get in the queue early to mitigate programme delays and price increases. So this may be via early instructions to contractors, via a letter of intent before a building contract signed. It may mean that live projects orders are placed for materials to be stored off-site. We're aware of two different developers, one in Scotland and one in England, who have proceeded to place orders for steel, notwithstanding that the design for the works hasn't been finalised. And I'm sure that those attending this morning will have similar anecdotal experience. As mentioned, so it's not to delay matters while other parts of the main contract are still being finalised. We're seeing employers agreeing to instruct the contractors to place early orders for materials via letters of intent or pre-construction services agreements. So this approach isn't new. However, the cost of these orders and the ones that we're seeing entered into recently are higher than we would usually expect, as contractors are advising that more materials are ordered pre-contract in order to avoid programme delays. While there's nothing inherently wrong with this approach, there are always risks for an employer that instructing a contractor in this way may not be as robust as a full building contract. There's also risk that the full building contract is not entered into. We would always recommend that any letter of intent is clear as to the specification and standards that any material should comply with. So the letter of intent should reference the drawings, the specifications, and also the most recent iteration of the terms and conditions of the building contract, and require the materials to comply with these documents. There should be a clear price for the materials and ideally prescribed cancellation costs that would be payable should the letter of intent be terminated for any reason. There should also be a mechanism by which the employers can secure the ordered items directly if the building contract is not entered into. So there should be a process for transferring orders to the employer should the building contract not go ahead. Due to demand for materials, clients and contractors may also agree to make advance payments to secure an order and prevent delays to the programme when works are on site. And this may be by securing materials and then storing them off-site. These advance payments should be secured by procuring on-demand bonds, vesting certificates, or similar documents transferring ownership. And the documents need to be very clear that title and materials passes on payment, even if they're held off-site, and that the materials are appropriately marked out as the developer's property and kept separately from the property of others. Agreements regulating the position of off-site materials are particularly important in Scotland, as under Scots law there's a distinction between contracts for the sale of goods and contracts for the sale of goods and services. For contracts which are sale of goods only, title transfers when the parties intend it to. However, for contracts involving the sale of goods and services, such as a construction contract, transfer of title only occurs after delivery when the goods are fixed to the structure. This distinction doesn't exist in English contract law, and so in England the sale of goods and services can be provided under one contract. So for those of you familiar with the JCT and SPCC suite of contracts, this is why they contain different provisions around transfer of title. This requirement can be problematic if goods are paid for in advance and stored off-site. because in the event of insolvency of the supplier, title will not have legally passed and they may be counted as part of the insolvent company's assets. So the most common solution around this in Scotland is for parties to enter into a separate supply contract or off-site materials agreement with the supplier of the goods and contractor. This agreement is a contract for the sale of goods only, and transfer of title occurs when the parties intend it to. When preparing these documents, it's important to consider the following key issues. Firstly, the transfer of ownership. Is it clear that ownership of the materials transfer to the employer upon payment and are not subject to any subcontractor or supply chain claims? Often subcontractor suppliers will be party to the agreement to confirm the point that ownership transfers. Again, it's important to set out the standards to which the materials are to comply with. By entering into an off-site materials agreement, the materials are removed from the ambit of the construction contract and are governed by the off-site materials agreement. Therefore, the off-site materials agreement needs to refer to the standards to which the materials must comply, and in practice, that's simply a cross-reference back to the building contract. It's important to consider how collateral warranties and performance security is affected. Again, because the materials no longer form part of the works under the building contract, they'll no longer be subject to collateral warranties, parent company guarantees, or performance bonds granted under that contract. And this point is sometimes overlooked, but it could be very significant. So if there was glazing panels for a new building, all procured via off-site materials agreement, and a subsequent defect in those panels, that might not be covered by the main contractor's warranty without bespoke amendments having been made to the document. If the cost of the materials being ordered is significant, does the employer require a separate bond to cover any failure to deliver the materials? Finally, storage and insurance. The off-site materials agreement should clearly state that the risk of storage and insurance lies with the contractor before they're delivered to site. The materials are clearly marked as belonging to the employer and for use on the project. Over recent months, we've seen a marked increase in the number of off-site materials agreements being required. And it's particularly important for those administering the payment process to ensure that satisfactory paperwork is provided before payments are made under these agreements. I'll now hand over to Alistair, who's going to talk to the effect that the PI insurance market is having on the sector and the draft building safety bill that was published during the summer.
Thanks very much, Lauren. As Lauren mentioned, I'm going to be looking at the insurance market, particularly in relation to professional indemnity insurance and how that's changed over the past year to 18 months. I'm also going to be looking at the draft building safety bill, which is currently making its way through the legislative process, specifically in respect of how it might affect parties' liability for fire safety defects in a post-Grenfell world. So one point that Lauren mentioned there, which is still in the news, is the instances that we're having in relation to tightening up of the market generally. And insurance is part of that, without any shadow of a doubt, and everybody I'm sure who is watching this will have noticed that. According to the recent Construction Leadership Council survey that was carried out in the UK, the resulting report, which was released on 31st March this year, the UK professional indemnity insurance market has seen significant premium increases. It's seen greater restrictions on extent of coverage, and it's seen greater exclusions. Now, this has naturally presented a real challenge for many parties whose business operations require them to hold such insurance. The report suggests that 60% of the survey respondents, and that's including contractors and designers, tended to have restrictions on cover which related to cladding or fire safety. 1 in 3 of the total survey respondents had a complete exclusion in place for cladding claims, and 20% had an exclusion for fire claims. Now, there is an appreciation that this is part of the ongoing impact of the Grenfell Tower tragedy. However, it demonstrates an overall tightening of the market, which will invariably have significant consequences for insured parties. Almost half of the respondents to the survey had recently been declined insurance by 3 or more insurers, and 2/3 have had to carry an excess imposed on them by their insurers. Anecdotally, premiums have increased by between 20% and 400% since last renewal, and the average rate of the premium to turnover is now at 4%. On the insurer's side, the average capacity per underwriter has halved since 2018, decreasing from £5 million to £2.5 million. This has led to parties who are seeking insurance having to source multiple layers of professional indemnity cover from multiple providers to be able to complete a layer, and that in turn increases the likelihood of additional restrictions being imposed. On top of the increase in premiums and restrictions, the availability of professional indemnity insurance is itself decreasing. A number of UK insurers now simply no longer support construction professional indemnity risks, and approaches across the insurance market are becoming more unified. It's now less common for a particular underwriter to offer significantly better terms than its competitors in the market, and requests for insurance which would previously have been well within underwriters' acceptable parameters at the beginning of last year are now being declined with some frequency. As far as terms of policies go, underwriters are offering narrower options here too. Unlimited reinstatements of aggregate cover are becoming less common, with insurers restricting cover to a finite number of reinstatements or even a single aggregate limit. Consequential financial losses may be excluded, with only rectification costs covered. And this may affect claims for loss of profit and for liquidated damages or the cost of delay. This particular exclusion will be of interest to main contractors, and it may be something that those taking innovation of key design consultants may look to resist. In respect of restrictions in cover which have been influenced by Grenfell, these may be stated as applying to fire safety or cladding claims. However, those concepts as stated may not be defined precisely, and therefore the exact scope of what the exclusions are from cover can be difficult to predict. And this also creates difficulties when negotiating the corresponding limitations or exclusions of liability under professional appointments. One thing to note is that a restriction in fire and cladding coverage availability is reflected in the 2020 edition of the REBA Standard Professional Services Contract for Architectural Services, which introduced new sublimits to the architect consultant's liability for loss or damages in respect of cladding or fire-related issues. The current difficulties in the professional indemnity insurance market have not only impacted the negotiation of new professional appointments, but are also likely to affect appointments already in place on developments that are underway or which have reached practical completion. Due to the recent increases in premiums and the introduction of more stringent restrictions, which I mentioned previously, consultants might find at the time of their insurance renewal that it's no longer commercially viable to maintain the levels of cover that are required in their existing professional appointments. Where a consultant's contractual responsibility under its professional appointment is aligned to PI cover that may be reduced or may become altogether unavailable over the course of time, the risk of underinsurance is in effect passed back from the consultant to its client. This can be seen in the fact that the professional indemnity insurance operates on a claims-made basis. Now, this means that the claims which are made they need to be in relation to the insurance which is available at the time that the claim is actually made. Oh, apologies, sorry, that shouldn't be coming up there. The insurance which is actually available at the time the claim is made, rather than the insurance at the time that the policy was entered into. And the insurance cover that will respond will be that which is at the time that the claim is made. And furthermore, the obligation to maintain professional indemnity insurance is often qualified by saying that it only needs to be maintained so far as the level and basis of professional indemnity insurance are stipulated in the construction document remains available at commercially reasonable rates and terms. It's therefore possible that if a latent defect arises a few years down the line on a completed project which is attributable to designer negligence, the insurance which is available to respond to a claim relating to that defect may not be as extensive as the relevant appointment or the relevant collateral warranty requires. So what can actually be done about this? The simple answer is that unfortunately there is no simple answer. Parties who are required to maintain professional indemnity insurance would be advised to maintain a good working relationship with their insurers and to make sure to the extent possible that they're seen as a low-risk client for the purposes of providing PI insurance. And this will make insurers more likely to be happy and confident in providing professional indemnity insurance at reasonable rates and on reasonable terms. Now, professional indemnity insurance isn't the only thing which has been affected in the aftermath of the Grenfell Tower tragedy. There's also a move to revise the legal framework in relation to available causes of action in relation to damages or defects relating to buildings. And that's in the form of the Building Safety Bill, which was published on 15th of July this year. This bill is largely applicable to England and Wales, but there are some sections which also apply in Scotland. From the perspective of any developer operating in England and Wales who's developing multi-occupied residential buildings of a prescribed height, generally 18 metres above ground level or 6 stories, the Building Safety Bill is something they need to be aware of. It significantly increases the period within which a claimant may bring a claim in relation to a building safety matter. Currently, under the Limitation Act 1980, the relevant period is 6 years from accrual of the cause of action, and following expiry of that period, a defendant may apply for the relevant claim to be struck out. The Building Safety Bill, on the other hand, proposes that this should be amended to 15 years from accrual of the cause of action. This would apply both retrospectively and going forward. So from the point when this comes into effect, this is backdated by 15 years in buildings that have been constructed during that time period. The intention of this legislation is quite aspirational. It intends to create a lasting generational change which sets a new baseline for how residential buildings should be constructed and maintained and made safe. It would allow residents in high-rise buildings to raise building safety concerns directly to the owners and managers of buildings, who would in turn have a duty to take cognizance of those concerns. Beyond that, it would also provide for the establishment of a building safety regulator within the Health and Safety Executive. And that would have as its aim the improvement of safety standards in buildings and the protection of people within buildings in relation to risks arising from them. From the perspective of building owners, they'll be required to demonstrate that they have effective, proportionate measures in place to manage safety risks, and there'll be potential criminal charges for those that fail to do so. In Scotland, the position is different on the whole. There's currently no plan for the Health and Safety Executive to take on any responsibilities in relation to building occupiers. Instead, they'll be concentrating on their responsibilities to workers. In 2020, the Local Government and Communities Committee of the Scottish Parliament invited the Royal Incorporation of Architects in Scotland to give their views on the adoption of the building and fire safety regulations in Scotland. And this is notable particularly as one provision of the Building Safety Bill which would apply in Scotland is the ability of the Secretary of State to introduce new regulations governing the competence of architects in Scotland. The RIAS's view was that this wasn't necessary, and indeed it was potentially counterproductive, particularly in relation to the Building Safety Bill's extension of the Secretary of State's powers to introduce regulations governing the competence of architects on the basis that there was no substantive evidence of failure by local authority departments in Scotland in this regard. The other key provision of the Building Safety Bill which would apply in Scotland is the ability for the Secretary of State to introduce new regulations governing the safety of construction products. And this would cover not only the ability of parties to sell these, but also to market them, to import them. It would affect the ability to use them if they had been placed within certain categories of products which were described as or felt to be by the Secretary of State dangerous to the health of those who would be using the completed buildings. Now, this can mean that the products would be recalled or withdrawn from use, and the Secretary of State would have the power to do that. It could also mean that products would need to have particular markings on them, or that packaging of a specific type would need to be used. It could mean that they would need to be stored in a particular way on site, and regulations in relation to all of these things are contemplated by the Building Safety Bill. In terms of what's being done in Scotland to address concerns in respect of building safety and fire safety, the Scottish Government launched its own review of the fire safety regime for domestic high-rise property, and that was back in 2018. The recommendations of that review in relation to introducing new fire safety legislation were limited, but it did acknowledge that fire safety enforcement, which is relevant to multiple owners, should be considered in the long term. In the meantime, the Scottish Government has introduced a number of separate measures that are designed to address fire safety in buildings. There are new requirements for smoke and heat alarms to be fitted in all homes. This was originally intended to come into effect this year, but has been pushed back to the beginning of next year. A new review panel is being set up on fire safety standards, and that's resulting in fire safety standards changes like cladding requirements on buildings over 11 metres, escape provisions in buildings over 18 metres, and introducing sprinklers to more types of housing. Again, this was originally intended to come into effect this year, but has been delayed to 2022. A new review panel has been established in relation to compliance and enforcement to strengthen procedural guidance on safety critical issues. A new Building Standards Futures Board has been established to focus on longer term building standards system changes to improve regulatory compliance. A new fire safety regime review advisory group has been established aiming to ensure better protection for residents in high-rise buildings. High-rise domestic buildings in Scotland are to be inventoried, and a new technical working group is to be established, developing advice on determining fire risks posed by external wall systems in existing multi-storey residential buildings. Whether separate measures in respect of extension of time limitations for bringing claims in respect of fire and building safety issues will be introduced in Scotland is still not known. But between the ongoing review of current measures and the increased attention paid to this area by insurers, there's certainly no doubt that this is an area we're going to be talking about for a long time to come. I'll now hand back to Ian for the second half of today's session.
Thank you very much, Lauren and Alistair. So we'll take just a very brief pause now before I hand over to our next speakers, Chiara and David. And this is just to do the first of our polls, which will come up in the screen which will come up in front of you on the screen just very shortly. And the question asked, which I'd request that you all please answer, so we get as full as possible feedback from the whole audience. The question asked is, do you consider the outlook for the construction sector over the next 12 months to be positive or negative? So I'd ask you all now, please, to tick whichever box you feel applies, whether it's positive or negative. And we'll just take a minute for the results to upload, and then I'll give you those results. So the results are in, which I'll now announce, and you may be able to see them on the screen in front of you, but the answer favours the positive. 64% of the audience consider the outlook is positive, and 36% consider it's negative. Now, hopefully that does reflect the reality of the construction sector going forward, rather than just simply we have an audience full of optimists. But anyway, that does feel positive, and that certainly reflects our own experience and what we are seeing. Okay, so thanks for that. So I'll now hand over to Chiara Pieri, who's going to give us a case law update, and she'll then hand over to David. Thank you.
Thank you, Ian, and good morning, everyone. So David and I have been tasked with providing a case law update. As I'm sure everyone has experienced, the construction world has been extremely busy, and so have the courts. So we've chosen 5 cases that we hope will provide some useful takeaway points. So we'll be taking you through 5 important recent judgments that have implications for the construction industry. The first is the case of Michael Wilson against Graham W. Cheney Builders Limited. The second is Downs Road Development LLP against Lazman by Construction UK Limited. The third is the case of Triple Point Technology against PTT Public Company Limited. The fourth is the EcoWorld case, Ballymore Embassy Gardens Company Limited against Dobler UK Limited. And briefly, we'll touch upon the case of Toppin Holdings Limited and Abbey Healthcare Mill Hill Limited against Simply Construct UK LLP. So it's worth highlighting that although the decisions were issued by both the Scottish and English courts, the English cases would have application in Scotland and are likely to be considered highly persuasive by the Scottish courts. So I'll cover the first 2 cases, being the Michael Wilson case and the Downs Road Development case, before passing on to David, who will focus on the remaining 3 cases. Just a reminder, if anyone wants to ask a question, then feel free to type them in the Q&A box and we'll answer these at the end. So the first judgment in our update is Michael Wilson against Graham W. Cheney Builders Limited, which was issued by the Sheriff Appeal Court in Scotland in August 2021. And in this case, the Appeal Court upheld an adjudicator's decision that an application for interim payment was valid, despite the application having been made to a contract administrator who had withdrawn from acting. As I'll set out, the 2 points to take away from this case are that first, an employer in a building contract has an important and continuing responsibility to appoint, and if necessary, replace an architect or a contract administrator if such a role exists under the contract in question. And if they fail to do so, then there may be repercussions for the employer, as will be seen in this case. And second, I think the case does show the continuation of the trend of the courts in supporting adjudicators' decisions. In fact, on Monday evening, I attended the Technology and Construction Court in England's update, who reported that they've seen an increase in adjudication enforcement cases over the past year. They reported that the court dealt with 70 enforcement cases in 2020, compared with 130 this year, and one of those decisions I'll come on to shortly. So the background to this case was that in 2016, the employer engaged Graham W. Cheney, the contractor, to build a house in Culton, Aberdeen, using a contract based on the standard form SBCC minor works building contract with contractor's design. Under the contract, the mechanism for making interim payments was that the contractor makes interim applications to the architect, the contract administrator, who in this case was WCP Architects. Now, the contractor made such a payment to WCP in February 2020. However, unbeknown to them, WCP had actually terminated its appointment as contract administrator in 2019, and no new contract administrator had been appointed. The employer failed to issue payment and disputed the validity of service of that interim application, and so the contractor referred the interim application to adjudication. So the adjudicator held that the interim payment application was valid in service, content and substance, and that the employer, Michael Wilson, was ordered to pay the full sums claimed by Graham W. Cheney, along with fees and expenses. And when payment was not made, the contractor then raised enforcement proceedings in the Sheriff Court. Now, in defending the enforcement action, the employer sought a declaration that the interim application was invalid, as well as challenging the adjudicator's decision on 3 grounds. So the first was that the adjudicator had failed to exhaust his jurisdiction. The second was that the adjudicator failed to provide adequate reasons for the decision. And the third was that the interim application was tainted by fraud due to alleged dumping of hazardous and illegal materials on site. At first instance, the sheriff granted summary decree in favour of the contractor on the basis that the employer had no real prospects of success, and the employer then appealed. And on appeal, the Sheriff Appeal Court upheld the adjudicator's decision that the application for interim payment was in fact valid. And this was on two grounds. First, that the application had been submitted in terms of the contract, in the absence of any variation of the contract or a replacement contract administrator. The service of the application to WCP, being the original contract administrator, was conformed to contract. Second, the court found that although the employer may have been exposed to prejudice by not replacing WCP as a contract administrator, it had exposed itself to the risk by failing to appoint another contract administrator for an extended period of time, despite the contract requiring the employer to do so within 14 days. The employer's decision not to replace WCP timorously was, according to the court, a conscious and deliberate decision taken at the employer's risk. Failure to do so therefore barred the employer from challenging the validity of the payment application on this basis. As a matter of general principle, and one which is certainly not to be forgotten, a party is not entitled to take advantage of its own wrong in enforcing contractual obligations. So as I've outlined, there are two points to really take away from this case. First, that employers must take the responsibility to appoint a contract administrator seriously. As we've seen, failure to reappoint one once a contract administrator has ceased to act might severely disadvantage an employer. And here the cost of failing to do so amounted to £263,337.53 plus interest. It is surprising that the standard form terms in question don't require formal notice to be served on the contractor, advising that the contract administrator has ceased to act. But that is how the court decided the case. And I think that the case does also show that the courts are willing to support adjudicator's decision. It seems to be a continuing trend, and therefore careful consideration should be taken when deciding whether to challenge an adjudicator's decision. And the court also commented in this case that the various arguments that were deployed by the employer appeared to be the type of contrived and technical defences that courts have long cautioned against, and which will be examined with a degree of scepticism. So the second case that I come on to is the case, the Downs Road Development LLP against Lazman by Construction UK Limited, which was issued by the TCC in August. And it highlights 2 points. First, that parties must ensure that payment notices issued by employers to contractors are thorough, complete and issued on time. This is something to watch out for, particularly if the reason for not certifying a sum in a payment certificate is due to reasons such as lack of time to consider it, or holidays, or issues with internal governance. Second, the consequences of an adjudicator failing to consider a line of defence made during adjudication are far-reaching. In the case, the TCC held that an adjudicator's decision not to consider a line of defence was a breach of natural justice and was consequently unenforceable. So the background to this one was that Downs Road Development LLP, who was the employer in the contract, engaged Lazman by Construction UK Limited, who was the contractor, in connection with the demolition of buildings and development of land under an amended form of the standard form JCT design and build contract. Under the contract, a periodic payment scheme required the contractor to make interim applications for payment. And when a dispute arose concerning the correct sum due under an interim application by the contractor, the employer issued a payment notice, which was payment notice 34, assessing a net payment due of 97 pence. And this was accompanied by a covering letter stating that a further notice would be issued in due course. And then 6 days later, payment notice 34A followed, which assessed a net payment of £657, £218.50, which is 600,000 greater than the original amount. The contractor submitted the matter to adjudication for determination of the correct sum due, and the employer submitted a counterclaim alleging losses suffered resulting from breaches of contract, including the non-provision of a warranty and defects in the design and build of a capping beam. The adjudicator made a decision on the net sum, but held that it did not have jurisdiction to consider the counterclaim. The employer then raised a claim at the TCC seeking a declaration that the adjudicator's failure to address the counterclaim was a breach of natural justice, and that as a result, the adjudicator's decision as a whole was unenforceable, following which the employer claimed no payment was due. So the employer separately contended that the adjudicator's decision could be seen as two distinct decisions on separate issues, namely a decision on the sum due in respect of the payment application and a decision on the counterclaim. The employer argued that the defective counterclaim decision could be severed, leaving the adjudicator's decision on the sums due, which should be enforceable. As a result, the employer hoped it could prevent the contractor relying on interim application 34 as originally formulated on a smash and grab basis. So the TCC held first that payment notice 34, the original notice, was invalid because it did not accurately state the employer the sum that the employer considered to be due, which is a requirement of section 110A of the Construction Act 1996, but rather that the payment notice 34 was simply a holding position, which was evident from the covering email that stated that a further notice would be issued, and then 6 days later payment notice 34A was issued. Second, the TCC held that the adjudicator had jurisdiction to consider the employer's counterclaim, and a failure to exercise it amounted to a deliberate failure to address a material issue. Doing so was a breach of natural justice, and consequently the decision as a whole was unenforceable. Had the adjudicator inadvertently failed to consider one of a number of issues, this would ordinarily render the decision unenforceable in England, which marks a difference with recent case law in Scotland, where even an inadvertent error in failing to exhaust jurisdiction has actually been seen to render a decision unenforceable. So third, the TCC held that it wasn't possible to sever the part of the decision that related to the counterclaim while enforcing the rest of the decision. This was because enforcing one part of the adjudicator's decision without the other would be artificial and inappropriate. The adjudicator had not been engaged in making a series of separate and potentially severable decisions. Rather, he was engaged in reaching a single decision that could not be severed. So the case really highlights two points, one in relation to employer practices and the other in relation to adjudicators' decisions. First, it's evident that employers should take sufficient care when issuing payment notices. They must be thorough, complete, and issued on time. Otherwise, they may be found to be invalid, leaving employers vulnerable to future smash and grab claims. Essentially, the lesson is not only to make sure that when issuing a payment notice that it does not itself contain comments which suggest that the amount does not truly reflect what is due, but also that emails, minutes, project correspondence around that time also do not suggest this. If there is any sense that a payment notice is simply a holding position, then this decision suggests that the payment notice will not be valid. Conversely, for contractors, if any of your project teams receive a notice that contains language like this, then you should seek advice, as there may be potential arguments that the notice isn't valid. Parties should also be aware of the consequences of an adjudicator's decision to restrict jurisdiction. The case of Downs Road shows how incorrect failure to consider an issue can result in a decision that is unenforceable. So I'll now pass over to David, who will discuss the remaining 3 decisions.
Thank you very much, Chiara. Today, I'd like to talk about 2 decisions which deal with liquidated damages, and finally mention the decision which deals with the definition of construction contracts under the 1996 Act. The first decision I'd like to talk about is a Supreme Court decision in a case called Triple Point Technology against PTT Public Company Limited. And in this instance, PTT was a commodities broker, and it placed an order with Triple Point, who was a software system supplier. So it wasn't a construction case as such. And that was for a new software system dealing with trading, risk management, and vessel chartering. The project contract provided for payment against certain milestones in the works, and it applied LDs in the event of particular delays. Payments were issued in respect to the first 2 stages of work. The project was then subject to delay, and Triple Point failed to complete any of the further stages. Triple Point sought payment of software license fees from PTT, and this was refused because no further stages in the works had been completed, and therefore no further milestones had been achieved. Triple Point then responded to that by suspending work pending payments and left site. PTT argued that this was a wrongful suspension of work, and it served notice requiring Triple Point to remedy its breaches of contracts, and when Triple Point did not do so, it formally terminated the contract. It then engaged another contractor to complete the works. Triple Point raised proceedings seeking to recover the sums it claimed due in terms of its invoices and the work that it carried out prior to termination. PTT counterclaimed for damages, including LDs. And there are a number of different points before the court, but the ones I wish to focus on relate to the application of the LD provisions in this particular contract. The other aspect of the case which I want to talk about insofar as the LDs are concerned is the extent to which the limitation of liability within the contract applied to the LDs, or whether it's carved out from the limitation provisions. Now, the case was heard by the Supreme Court, but before it reached there, it was dealing with the decision at first instance. And in that decision, the court found that PTT was entitled to approximately $3.5 million for LDs for delay, as well as other incurred costs. And it said that Triple Point's decision to suspend work was a breach of contract. However, the decision didn't address all of the issues with regard to how the LD clauses ought to apply, and the matter was appealed to the appeal court in England. The Court of Appeal held that LDs were not due for the period beyond termination of the contract, and that PTT was entitled to liquidated damages in respect of completed and accepted works only. The key point in the contract was that the LD provisions were said to apply in respect of the period from the date that the work should have been completed up to the point when the works actually were completed. In this instance, the works had not been completed by Triple Point, and therefore the appeal court said on the correct application of the provision in question, LDs did not apply. And then on the question of whether any contractual limitation of liability applied to the LDs, the court held that the relevant clause created an overall cap on the extent of Triple Point's total liability, and that included its liability for LDs. And that turned upon the precise terms of the limitation of liability provision within the contract. So we had the situation where effectively the appeal court had held that the LD mechanism did not work in the circumstances in which there had been a termination. The matter was then appealed to the Supreme Court. The Supreme Court rejected the Court of Appeal's decision on that point. It held that the effect of the LD provisions should normally finish when a contract is terminated, but importantly should apply to incomplete works to that date, as well as those works that were completed and accepted. It agreed that the contractual cap in this case covered the LDs. The first point to highlight is that the LDs clause requires careful drafting, but in this instance, the Supreme Court looked at the provision and considered it against commercial background and decided that the parties must have intended that the LDs would apply up to the period of termination, even although the works were not completed, and therefore it interpreted the clause on that basis. It also highlighted the general law provision, which is that rights which have accrued up to the point of termination, unless there are express wording to the contrary in the contract, would normally held to remain in effect, even although the contract itself has been terminated. Generally, the effect of termination is to release a party from future performance rather than to relieve it of its past failure to perform. So I'd now like to look at a second case to do with LDs, which is EcoWorld Ballymore Embassy Gardens Co Limited against Dobler UK Limited. And again, this was a situation where one party was seeking to argue that the LD provision ought not to operate in the circumstances of the particular case. In this project, the employer, EcoWorld, engaged the contractor Dobler UK to carry out design, supply and installation of facade and glazing works on 3 residential tower blocks in London. there was an agreed LD provision which applied on a failure to complete the works. However, in addition to the LD provision, there was also a provision which allowed the employer to take partial possession of the works. And there was, however, no corresponding clause which dealt with a reduction in the contractor's liability for LDs should the employer choose to do that. So as matters transpired, the employer took over 2 out of the 3 tower blocks at an earlier stage, and then sought to apply LDs at the full rate until the date that the 3rd tower block was completed. And the contractor argued that this was unfair and effectively operated as a penalty because the employer had had the benefit of the first 2 tower blocks being occupied, even although the 3rd tower block was not yet finished. The court looked at the provisions and said there was nothing within them which prevented them from operating in accordance with their terms. The argument that the provisions operated as a penalty was not accepted. The courts take the approach that unless the imposition of damages is unconscionable, which is the test from the earlier Supreme Court decision of McDessie, then they will be enforced. In these circumstances, the employer had a perfectly rational desire to make sure that the building was completed on time, and accordingly there was no reason commercially why the imposition of liquidated damages should be seen as unconscionable in the sense used by McDessie. The final point that I'd like to just touch on is the case of Toppen, and this was a case which dealt with a collateral warranty, and the issue here was whether a party could commence adjudication provisions on the basis that the collateral warranty which had been entered into by the parties was a construction contract for the purposes of the 1996 Act. And what was important was whether it was anticipated that construction operations as defined in the Act were due to be carried out in terms of the collateral warranty. Because if there were no construction operations, then it could not be seen as a construction contract. Now, the circumstances here were quite unusual because the collateral warranty had been signed sometime after the works had been completed, and also after remedial works had also been completed. And I think there'd also been a settlement agreement thrown in there as well. So the court looked at the surrounding circumstances and considered the terms of the collateral warranty. And it held that a collateral warranty would not always be a contract for construction operations, and it needs to be looked at on a case-by-case basis. In this case, the parties did not legitimately expect that there would be any construction work carried out under this collateral warranty, because by the time it had been executed, the works had been completed, as had the remedial works, and therefore the court held that this was not a construction contract for the purposes of the Act, and accordingly an attempt to bring an adjudication meant that the adjudicator did not have jurisdiction, and the decision of the adjudicator in this instance was held to be unenforceable. So that concludes our look at the various cases that we've discussed. I hope you found them useful, and if there are questions, then we'll be happy to deal with them. But I'll now hand back to Ian. Thank you very much.
Thanks, David. So we'll now pass on and consider our next poll before we look at some of the questions that you've typed into the Q&A box. And thanks very much for those, and do continue to type them in now if you have any more. So that concludes the formal part of our presentation. You should now see up in front of you in the screen our second poll, which asks the question, do you consider there will be an increase or decrease in disputes in the construction sector? And that's over the next 12 months. So please, will you all tick the box that you consider applies? So that's increase or decrease, and we'll just pause for a moment to await the results. Okay, thank you very much. So the results, I think, should be in the screen in front of you. And just for clarification, we as a panel are not entitled to vote, so these results are purely coming from you as the audience, but you'll see there's a very strong expectation that the number of disputes in the construction sector will increase in the next 12 months. A very, very strong majority 97%, and we have 3% of optimists that are hoping that disputes will decrease. So that does reflect our expectation. Possibly the majority in favour of increase is somewhat higher than we might have expected, but that does really reflect some of the issues that are around in the industry and that are likely to feed through in the next 12 months. I suppose what that tells us is that we should all be looking at ways now to mitigate or avoid disputes, and the clearest way of doing that is when you see a dispute emerging on your project, to take action as soon as you possibly can to try to resolve that, because the experience, I'm sure, of all of us is if you allow disputes to run on, they tend to become bigger and more entrenched and more expensive for everyone involved. So that's certainly a trend for us all to watch out for over the next 12 months. So thanks very much for completing our polls. That's very interesting. We do have a number of questions which I will now pose to some of our speakers. The first question is in relation, this is for Lauren Thompson, our first speaker, and this is in relation to the availability of PI and the restrictions that we're seeing coming through. And the question is as follows: how are founders reacting to the hardening of PI availability and the increase of PI exclusions and aggregations? Are they accepting of certain categories of the resultant gaps? Lauren. So
I would say I think this is probably maybe looking at funders' view of the PI market, and I think what we're seeing at the moment is that funders, probably like developers and purchasers and tenants, are having to look at the package as a whole when they're looking at PI availability, exclusions, etc. So I think as a developer, and certainly when we're advising a developer and you're looking to satisfy funders in terms of their requirements, it's about trying to demonstrate that the package of insurance cover as a whole is suitable for the project and reflects, where we are in the market. So looking at what contractors can offer if it's a D&B contract, looking at consultants, subcontractors as a second level of comfort there. Also thinking about the covenant of the borrower, the nature of the works, and we have seen in some cases where PI insurance, there's maybe been certain exclusions or lower limits for matters in relation to fire safety, etc., and actually being able to set out the practical processes of what's being done on site and what the checks and balances are within the contract in terms of maybe extra levels of testing, etc., has helped to also get parties comfortable with actually the process for the design and completion of the works, as well as looking at the PI sitting behind it. I think also it will give rise to queries about latent defects insurance, which people always raise as, is that necessarily a solution for projects as part of the insurance package? I think depending on the project, we tend to see that for very complex office sizable office projects, etc. Perhaps not in terms of obviously infrastructure housing projects. And I think one point to think about in terms of latent defects insurance is that there's inevitably exclusions for various types of defects, and so certainly latent defects insurance is maybe a part of an insurance solution, but it's not the solution if there's issues with PI availability. So I suppose coming back to the original question, it's just trying to build a package of insurances, a package of reliance that then can be presented to funders, purchasers and tenants and considered as a whole.
Okay, thanks very much, Lauren. And I'd just ask you to address the next question also, please, because it arises from your presentation. And it's in relation to the outlook for the construction sector and the issues that you spoke about regarding the lack of operatives and materials and so on. One of our audience thinks that the sector may still be struggling with these issues in 12 months and is asking for our view. And I wonder, because you have a very wide view and cross-section of the sector because of the various different clients and contractors and consultants that you deal with. I mean, is it your expectation that these issues will be resolved?
I don't think they'll be resolved. I think certainly some of the data that's coming through suggests that things are improving, but it's certainly maybe unlikely to be resolved within the next 12 months. And I think you can probably almost take the materials, or maybe separating the two. In terms of materials, I think because we're seeing, early orders, off-site materials agreements, we're seeing more and more of that. So the industry is trying to work around some of the issues and the challenges that's being presented to it in terms of availability of materials. I think inevitably the contractors and subcontractors that are able to offer the supply chain bigger order books, etc., are going to be better placed. And it may be the smaller contractors that might struggle in terms of securing materials, and the same, I guess, in terms of operatives. It's obviously slightly harder in terms of to see what the solution is in terms of operatives going forward. I know that in terms of some of the studies done, one of the big concerns is actually the number of people working in the construction sector that will be coming up to retirement within the next 5 years or so, and that's a significant number. So I think the challenge is going to be getting more and more people to actually look at construction careers. And certainly I think in terms of some of the surveys, I think the wages in the construction sector in terms of the increase in wages is one of the largest when compared to other sectors. And I think certainly as an industry, we need to be looking at what are we doing to kind of bring young people through and I suppose fill some of the 35,000 jobs that are currently being advertised in the sector. So I think probably materials, I would like to think that there's processes and things will improve, but I think that the challenge in terms of operatives and securing the necessary personnel is going to be more difficult.
Okay, thank you, Lauren. That's very helpful. We have two questions, and I think these apply to the cases that you spoke about, David, just latterly. I think the first question is directed to the final case that you spoke about, and that was the one on collateral warranty, the Topham case. And the question is whether you think that the outcome in that case would have been different if the collateral warranty in question had been completed before the construction works were finished.
And I think it probably would have done. What the court was doing was looking at the words in the actual collateral warranty itself and considering whether it was sufficient to cover any construction operations actually been undertaken. And it was an examination of the contract itself against the factual background, and the factual background being that all conceivable works had actually been completed led to the result. So if the words in the collateral warranty were sufficiently broad enough to cover further works being required, for example, the obligation to carry out remedial works, and there were remedial works which were still required to be undertaken, then I think the outcome would have been different.
Okay, thank you. And just a final question then before I close the session. Again, this is for you, David. And this relates to the triple point case that you dealt with, the first of your cases. One of our audience understands the outcome in that case to be that LD cease upon termination and that general damages can thereafter be claimed. Now, if that's right, and I think that's what you said, in that case, could that lead to double recovery of damages if LDs have already reached the maximum at the point of termination, and then general damages for delay are claimed in addition to that beyond the point of termination?
And the question is absolutely correct. The case did decide that general damages could be claimed after the period of termination. That there ought not to be double recovery, because it would depend upon what the general damages are that were being claimed. But on the assumption that they were time related, they should cover a different period of time from the period covered by the LDs. So there ought not to be a double recovery. That can get difficult in practice to separate them out, but on the assumption that the general damages were time related and therefore covering the same types of loss would be covered by the LDs, there shouldn't be a double recovery, because the general damages would apply to a different period of time and there shouldn't be an overlap. That's the simple answer. In life, it could be a bit more complicated, but that's a simple answer.
Very good. Okay, well, thanks very much, David. And I'll now just say a few words to close the session formally then. Thanks, first of all, to all of our speakers. That's been very helpful, and I hope you as the audience have found it informative. And thanks also to the speakers, and principally Lauren and David, for answering the audience's questions. If there are any more questions, please, anyone in the audience, don't hesitate to get in touch with us individually, and we can answer those by email, as they arise out of the session. And just as a reminder, a link will be sent to you all in the coming days with a recording of the session, and that will allow you to listen to parts of it again if you didn't pick them up, or please also feel free to share the link with your colleagues. If you think any one of those would be interested. We'll also reconfirm the results of the poll, and you might again want to share those with your colleagues and perhaps debate if there are any suitable actions that you might want to take to consider those. So just finally, thanks very much for tuning in. We hope you've found this session useful and helpful. We hope to meet you all in person individually soon. It seems that circumstances are such that should be more possible in the coming months. So we do hope to be seeing you in person. That's very much our wish, but we hope this session has been in a useful format. And if anyone has any feedback on the format, timing, etc., please provide that to us by email or by telephone call, because we're always very happy to get that feedback so we can shape our future events around it. So thanks once again, and we hope you enjoy the rest of your day. Thank you.